versus Ashley Clark, 22 CR 216. Mr. Fosgrove.
No. Your Honor, this comes before the court today on a probation violation hearing. And it's the intent of the defendant at this time to stipulate. And I do believe there's a agreed sentence, as you would say in this case.
All right. Ms. Clark, you've heard the announcement of your attorney. Is that what you want to do? Admit to the violations?
No, actually, I'm going to make a motion for my attorney to withdraw. I got this myself.
Oh, okay. What's the reason for that?
I just want to represent myself.
Okay. All right. Well, somebody give her a waiver of attorney form. Okay. It's muted for some reason. All right.
Welcome back to the courtroom, folks. And buckle up, because today's case is straight out of legal soap opera. Meet Ashley Clark, a self-proclaimed sovereign citizen who's decided she doesn't need a lawyer. Big mistake. We're about to watch a full legal train wreck. A woman fired her attorney on a probation violation hearing and thinking she can outsmart the court using YouTube pseudo-law. The judge? Calm but deadly. The prosecutor? Patient but sharp. And Ashley? Well, she's about to turn this hearing into a masterclass in courtroom chaos. Stay tuned, because what starts as a routine hearing quickly spirals into sovereign meltdown terror.
Well, I've already gone over these rights with you, so you should understand them, but you have the right to hire your own attorney. If you can't afford to hire an attorney, I've already appointed one. You qualified. You do have the right to represent yourself as well, and that's what you want to do today?
Yes, sir.
All right. If you want to waive your right to an attorney, when we do this, you have to follow the rules of procedure and evidence, just as if you're an attorney. You understand that?
Yes, sir.
All right. Has anyone promised you anything or threatened with anything to get you to waive your right to an attorney?
No, sir.
All right. Looks like you've already signed it and sent it in here. Did you understand this form you signed?
Yes, sir.
I'll accept your waiver and allow you to represent yourself. All right. Are you wanting to stipulate to the violations, or do you want a contested hearing?
I'm going to contest it.
All right. Mr. Hollis here.
Yes, Judge, I can grab him real quick.
Okay. Okay, state has the burden. Any opening statement, Mr. Marcinski?
No, sir, thank you.
All right, Ms. Clark, any opening statement?
And there it is, the first red flag. When a defendant fires their attorney right before admitting to a probation violation, it's not empowerment. It's self-sabotage. Sovereign citizens love the illusion of control, believing that rejecting the system somehow frees them from it. But in court, that confidence crumbles fast. Notice how calm the judge stays. That's not indifference, that's experience. He's seen this act before. Ashley's walking into a legal minefield armed with Google law and blind confidence. The scary part? She doesn't even realize the trap she just set for herself. This is where most defendants start sweating. The judge just made it clear. If you represent yourself, you follow every single rule a lawyer does. No exceptions, no shortcuts. And that's where sovereign citizens always stumble. They crave independence but forget. Courts run on procedure, not passion. Ashley thinks she's gaining freedom by ditching her attorney, but she's really signing up for a one-way ride to failure. When judges warn defendants about the rules of evidence, that's not filler talk. That's a flashing neon sign that says, you're not ready for this.
All right. State may call this first witness.
Thank you, sir. The state would call Court Service Officer Christopher Hollis. Sir, will you please state your name for the record?
Chris Hollis. I'm a court services officer.
In that job occupation, were you assigned the supervision of a Miss Ashley Clark? That supervision being for an endangering a child underlying 12-month sentence?
That is correct.
On May 18th of this year, 2023, did you test Miss Clark for the presence of drugs?
Yes,
And what was the result of that UA sample from Miss Clark?
it was positive for methamphetamine.
So her
stating that
UA was positive for methamphetamines, and she also, in response to that positive UA test, signed in a statement of admission of using methamphetamines.
that's correct.
Did you order her to report on June 2nd, 2023?
I did.
And did she appear on that day?
She did not.
Has she appeared or reported to you since that time?
No,
Sometime after May 24th of 2023, were you advised by local authorities of her being arrested for a new crime?
yes, and I did. I received that, and apparently she has new charges.
To your knowledge or to the notes, did Ms. Clark ever report that negative law enforcement contact with your office?
No, she did not.
That will be my questions for Mr. Hollis at this time, Your Honor. Thank you.
All right, Ms. Clark, do you have any questions for Mr. Hollis?
This right here is the moment reality starts setting in. Ashley wanted to represent herself, but when it's her turn to question witnesses, she freezes. It's a textbook case of courtroom confidence collapsing under pressure. Watching this, you can almost hear the judge's internal sigh. He knows exactly where this is heading. These sovereign types spend hours memorizing legal buzzwords, but none of that prepares them for real evidence, real witnesses, and real consequences. It's not a debate club, it's a legal battlefield. And Ashley just dropped her shield. And here's where the fantasy collides with reality. Ashley starts invoking jurisdiction and injured parties. Classic sovereign talking points pulled straight from fringe forums. The irony? She's arguing about imaginary laws while the state presents real evidence. Drug use, missed reports, and new arrests. That's a sovereign paradox. Fighting the system while proving the system's point. The prosecutor doesn't even need to argue hard. Ashley is doing the work for him. Every baseless claim she makes just tightens the rope around her own case.
All right. Do you have any further evidence or witnesses, Mr. Marcinski?
Not at this time, Your Honor. I do not.
All right. Ms. Clark, you have time to, now it's your turn to present any evidence if you want to. Do you wish to present any evidence?
Right now I see no evidence. This has the needed personal subject matter jurisdiction.
If you want to present any evidence, do you want to present any evidence?
No.
No? Okay. Well then, closing argument, Mr. Marcinski?
Your Honor, at this time, the state believes it is shown by a preponderance of the evidence that Ms. Clark is in violation of her probation and conditions of probation imposed by the court therein. The state's going to ask that you find that she is in violation of that probation. The state would point out that this is a misdemeanor probation for endangering a child. Therefore, Ms. Clark is entitled to no graduated sanctions, intermediate sanctions, or other relief set forth by the legislature on felony probations. Due to the litany of violations, the continued drug use, the failure to follow through with her treatment requirements, the state believes that she's shown that she's not amenable to probation and would recommend the court revoke and remand her to serve her underlying sentence.
This closing argument is pure sovereign theater. No facts, no defense, just buzzwords. Ashley calls the state a fictitious plaintiff, mentions the IRS, and even claims she's a surety. None of that means anything legally. Judges hear this gibberish every month from people convinced they've found a magic loophole. But here's the truth. The law doesn't bend for belief systems. The more she talks, the deeper she digs. Instead of defending her actions, she's showcasing why self-representation, without understanding the law, is a guaranteed disaster.
There are no facts to dispute before this court. I see no evidence that has the needed personal subject matter jurisdiction. The state is a fictitious plaintiff. The state of isn't here to testify. No injured man or woman is present before this court to provide firsthand knowledge. I am acting as surety for the named principal to contest jurisdiction. I am aware this is a taxable event and an excise tax is owed, and I want to be in compliance with the IRS code.
And there it is. The hammer drops. The judge systematically lists each violation and revokes probation. It's calm, methodical, and final. Ashley's strategy collapsed under the weight of real accountability. And yet, even in defeat, she clings to delusion, demanding $1,200 a minute for her jail time. Let's do the math. That's $1.7 million per day. You can't make this stuff up. This is what happens when online pseudo-law meets actual courtroom authority. The lesson? Sovereign citizen ideology isn't just wrong. It's expensive, embarrassing, and jail-bound.
It'll be the order and judgment of this court. Well, first of all, I'll make my findings. The state's shown by preponderance of the evidence that you violated probation in this case using methamphetamine around the 18th, as evidenced by the 18th of May this year, as evidenced by the positive UA and the admission. Also find that you failed to report in violation of probation as alleged. That would be the June 2nd, 2023 date. You failed to successfully complete outpatient treatment at Summer Mental Health as ordered by the court, so I find you violated probation there as well. You also failed to report law enforcement contact within the business day in violation of the orders of probation. You have violated it does in a very substantial way. I will go ahead. It appears as if probation will be a waste of time in this matter, so I will revoke and remand you to serve your sentence, take her into custody.
All right. $1,200 every minute I'm in jail.
So what did we just witness? A textbook example of how arrogance and misinformation collide in the courtroom. Ashley Clark turned a manageable probation violation into full revocation, all because she thought firing her lawyer made her powerful. In truth, it just made her unprepared. The judge remained patient. The prosecution stayed sharp, and justice did exactly what it was supposed to do. If you found this case as shocking as we did, hit that like button, drop a comment below, and subscribe for more wild courtroom breakdowns.